item on the agenda is to consider the decision of the Chief License Inspector to refuse the issuance of the 2024 business license to Uriah Lamour for a short-term rental accommodation located at 703 188 Kiefer Place. Before we begin, I have some opening remarks. This hearing is being convened by electronic means as authorized under Part 14 of the Procedure Bylaw, City of Vancouver Electronic Meetings. As such, panel members may participate in person or by electronic means. In case of an emergency, if we need to evacuate the building, I would like to direct your attention to the exits. There are 2 exits beyond the glass doors and to the left. If the glass doors are obstructed, please direct your attention to the 4 exits in the chamber. And please use the stairs and not the elevator. I would also like to highlight that there is a defibrillator located at the end of the hallway outside the council chamber. We acknowledge that we are located on the unceded homelands of the Musqueam, Squamish, and Tsleil-Waututh people. We thank them for having cared for this land and look forward to working with them in partnership as we continue to build this great city together. I also would like to take a moment to recognize the immense contributions of the City of Vancouver's team members who work hard every day to help make our city an incredible place to live, work, and play. Clerk, may we have the roll call, please?
Councillor Meisner to the chair, Councillor Fry, Councillor Montague, your quorum chair.
Thank you very much. So we will now start with opening remarks from Ian Dixon, Council for the City of Vancouver. Good morning.
Members of the business license panel, this is, as you've heard, we are doing 2 business license hearings this morning. The first of which is with respect to Mr. Lamour at 703 188 Kiefer. And just I'd like to introduce you to Mr. Schrag. If you could just come forward, please, as counsel for Mr. Lamour on this matter. You can just have a seat at one of the friends up there so that we can have quick access to the podium. I assume your client's not here? Well, not required to be. Members of the business license hearing panel, your powers to issue a business license are set out in section 275 of the Charter, which states that the granting and refusing of a license to an applicant, therefore, and the revocation or suspension of a license which has been granted shall be deemed to be the discretion of council, and council may grant, refuse, revoke, or suspend the license without stating any reasons therefore, save in respect of a licensee who is by reasonable efforts cannot be found. The council shall not revoke a license without giving the holder thereof an opportunity to be heard. You have very broad powers to issue or deny a business license. Pursuant to your business license powers, the council as a whole, rather than the business license hearing panel, has created the license bylaw. And of particular importance with respect to this particular hearing this morning is section 4 of the license bylaw. And section 4 of the license bylaw states that the Chief License Inspector shall issue a license except in certain circumstances. And one of those circumstances applied here today. So it states at subsection 3, on receipt of an application and before issuing any license thereon, the inspector shall ascertain whether the applicant has at any time within the preceding 5 years been convicted of any offence under any statute of Canada, province of British Columbia, or elsewhere, or under any bylaw of the City of Vancouver, and the inspector, if of the belief that the nature of the offence relates to the business, trade, profession, or other occupation for which the application has been made, shall refuse to issue the license. If the inspector refuses to issue such license, the applicant may appear before council, who may grant or refuse the application. Now, the upshot of that section is that if the Chief License Inspector, as in this case, concludes that there was a previous conviction related to, in this case, a short-term rental business, and that it relates to the current application, and it occurred within the last 5 years, she's obliged to refuse that license. You are not, as the business license panel of council, are not bound by that restriction. It's open to you to issue the license regardless of that. That portion of the bylaw only applies to the business license, to the Chief License Inspector, and that's the Chief License Inspector has acted as she's required to do by the bylaw, and as there was in 2020 a bylaw violation notice that Mr. Lamour opted to pay, and thus agreed that they had pled guilty to. So this morning's hearing is simply whether or not you wish to exercise your discretion to issue the license at this juncture. So what I propose to do is to take Ms. Hicks through the brief history and have her give you her opinion on what action she would have taken in the absence of there having been old ticket pay.
Great. Thanks very much, Councillor Dixon. We will now hear testimony by the City of Vancouver witness. Sarah Hicks, please go ahead.
So, Ms. Hicks, I'm just going to take you, I'd like you, tab 2 of the book of materials that's been provided that everybody has. I don't propose to take, given the nature of this, I don't propose to take you through each and every item, but there's a comprehensive timeline here starting at tab 2, page 4 of the book of materials. Ms. Hicks, if you could just take us through that to explain the background here.
Certainly. Mr. Lamour has a number of locations that have a history with the city related to short-term rentals. He owns and owned a number of units within the city. Mr. Lamour first applied for a short-term rental in 2018. Subsequently, in a year later, in March of 2019, there was another license issued to both Mr. Lamour as well as a Maria Lamour at a separate address at 689 Abbott Street. 689 Abbott Street is significant because this is the unit in which Mr. Lamour was ticketed during an audit. Sorry, I apologize. 689 Abbott Street had been inspected and found to be operating as a rooming house. That means that there are multiple units, multiple rooms within the particular unit that are being offered all generally at the same time for occupancy by renters. The location was subsequently audited. And the decision was made by Maria to cancel the license. The unit continued to operate past then, and in August of 2020, a bylaw violation notice was sent to Mr. Lamour, as well as to the property owners for operating without a business license. That ticket was subsequently paid, and a new application came in on August 17th by WERA to operate a short-term rental at 689 Abbott Street. At that same time, Mr. Lamour requested a closure of his license at 703-188 Kiefer Place. The application review was issued at 688 Abbott Street at, my apologies, Mr. Lamour applied for and received a license at 2908 688 Abbott Street. That license had been issued and renewed once for the 2023 year. On May 1st of 2023, that account was closed by Mr. Lamour prior to applying for a license at 188 Kiefer Street. We requested history from the previous licenses connected to Mr. Lamour to help document and show us an understanding of the principal residency. That information had not been provided related to the application. When an additional license at 705 689 Abbott Street, which is another unit that Mr. Lamour is connected to, an inspection request was sent for that particular unit. The license was closed in response to that request. Subsequent to that, we received a license application for the same unit by another individual. That application was not supported as upon inspection there was found to be work without permit in the unit. Another application was received at 688 Abbott Street by another individual, Marcello, that application was withdrawn through the application review process.
Can I just stop you there? And those are affiliated to Mr. Lamore because he owns those properties, is that correct?
Mr. Lamore owned or co-owned 3 units. I believe at the moment he owns one and co-owns another.
Yes, go on. So we're now at the timeline of the current application?
Correct. For the current application at 188 Kiefer Street, Mr. Lamore had applied in May of 2023. This was immediately thereafter closing the unit at 688 Abbott Street. The information received during the application process was confusing, particularly in relation to timelines. Mr. Lamore had advised that he had moved in March of 2022, which would have meant he operated a unit without being a principal resident for upwards of a year before moving over to this unit. Then that changed to be July of 2023. During an inspection with city staff, property use inspector, Mr. Lamore noted that he did not live in the unit. As well as on his application documents, he had indicated that he would live at a hotel unit during the rentals. So throughout this process, staff certainly found the timelines confusing. Mr. Lamore had a difficult time clarifying those timelines and tenants and ownerships with staff. So ultimately, the decision had been made to not support the issuance of the license to Mr. Lamore. That was sent in March of this year. Mr. Lamore applied again a month later, looking for a short-term rental. It was during this time that staff did a thorough historical view of Mr. Lamore's past properties and connections to short-term rental and found that there was the ticket for operating without a license in 2020 that had been paid, and therefore I would have to deny the license on that basis. That occurred in June of 2024.
So you've given us a bit of history with respect to Mr. Lamore, and obviously, had you had to make a decision, you were obliged by the bylaw to make a decision to reject the license because of the relation between the ticket and a short-term rental, a previous short-term rental. Based on the information that you were provided with, absent that previous conviction, would you have would you have issued a license to Mr. Lamore or not?
I think outside of the issuance of the ticket, if Mr. Lamore had continued to maintain the unit as his principal residence, we would have considered the issuance of a license to him.
Would you have any concerns if a license was issued to Mr. Lamore by the panel this morning?
If he maintains it as his principal residence as of today, I would not have a concern.
Those are my questions.
Okay, thanks very much. Panel members, if you have any questions for the witness, please place yourself on the speaker's queue. Councillor Montague.
Yeah, thanks. I guess my questions are around how long has 703 188 Kiefer, has it been operating without a license as a short-term rental? Or is there evidence that it's been operating as a short-term rental without a license?
Give me 2 seconds. To staff, we're checking this morning.
Because it was...
No, staff have not found any active listings for the unit in question today.
Okay. So other than at this point, other than the previous violation in 2020, 2020, I believe he was given the violation in, the city doesn't know of any specific violations against the short-term rental rules, either the provincial or city policies.
Correct.
Okay. I think that's all I have for now, Chair. I may have another question.
Okay, thanks, Councillor Montague. Councillor Fry.
Thanks. So you referenced the operation as a rooming house. Is that covered under the short-term rental? No, I think that was specifically for 689 Abbott. Is that also for 188 and 688? 188 Kiefer and 688?
For 188 and for the unit at 689 Abbott, both had operated as rooming houses, renting out multiple rooms to multiple people during the same time. There is an order on file for Mr. Lamour related to that in February of 2020. We don't have evidence that continued after that point.
Okay. So, but rooming house per se is not consistent with is consistent with the short-term rental bylaw.
So the short-term rental bylaw states that you can only host one reservation or one client at a time. You could rent to one family, let's say, that would take up multiple rooms. That would be fine, but you can't host multiple separate reservations in your home. That appeared to be what was occurring in that circumstance.
But that's pretty clear in the license agreement. Yeah. Okay. I'm confused. Who are Olivia Ma, Miriam Gregorio, and Marcello Carvalho?
Olivia Ma.
Three different licensees within 2 years at one address. Is that? Oh, I guess who are they, and is that a typical scenario that we would see?
Olivia Ma, we understand to be a co-owner at 705, at Unit 705, 188 Kiefer. The rest of the individuals we understand to be tenants of Mr. Lamour's throughout the different units.
Okay, and but Olivia Ma was 689 Abbott Street, although an owner at. I may have brought that down wrong.
My apologies. I don't have all the names and addresses memorized off the top of my head.
Totally.
I understand that Olivia Ma is the co-owner at 705 188 Kiefer. 705 188 Kiefer, you don't have a particular evidence package related to that, but 705 is referenced throughout the conversations with Mr. Lamour.
Right, and I see here Olivia Ma did have a license at 705 689 Abbott from March 18th, 2022 to January 1st, 2023. I can see how this would be confusing because it seems like there's lots of stuff going on.
Yes.
Okay, thanks. I'll jump off for a second, make space for Councillor Montague.
Okay. Thank you, Councillor Fry. Councillor Montague.
Yeah, Councillor Fly started to go down where I was looking here. So these other addresses, the 3207 at 689 Abbott, the 2908 at 688 Abbott, 705 at 689 Abbott. Are these still currently either owned or co-owned by the applicant?
We understand that 2908 688 Abbott is now sold and is no longer under the ownership of Mr. Lamour. I understand that 705, the unit 705 is still co-owned. And the unit that we're talking about today, 703 188 Kiefer, is owned.
Okay, and the other units that he either owns or co-owns, are they being operated as short-term rentals? Are they being operated long-term rentals? Are they lived in by the co-owners? Do we know that?
I apologize, I don't have that information on me today.
I think that's it, Chair. Thanks.
Okay, thank you, Councillor Montague. Councillor Fry.
I guess last question. I mean, so as we know, these business license hearings take time and resources was Mr. Lamour appraised of why his license was not, fulsomely appraised of why his license was not being recommended for renewal? And I'm sure we'll hear from his counsel on this, but was he given a very clear understanding of why?
Related to this hearing?
Yes.
Yes, staff advised as a result of the ticket that we had no ability but to deny
Yeah,
the license, and that was based off the past history.
So I'm sure, okay, that's great. Thank you. Appreciate it.
Hey, thanks, Councillor Fry. And I put myself on the queue as well for a question. I saw in the report a mention of asking Mr. Lamore to cease using, I believe was a storage room as a bedroom. Can you explain under the STR bylaw the issue with that?
Certainly. The ceasing to use a space that is not approved as a sleeping unit is in line with the Vancouver building bylaw. So a storage room is not built to a capacity to allow for occupancy in the sense of sleeping in it. So an order was advised to cease using those non-dwelling related spaces. And the license bylaw has language related to only using a unit as a legal dwelling unit. The entirety of the unit is certainly a legal dwelling unit, but the storage room is not.
Okay, and there's evidence that Mr. Lamore was renting out that particular storage room as like a separate Airbnb listing. Is that correct?
Prior to this application, yes, in 2020, which should be part of the tab 3.
Okay, thank you. And then my other question was, and I don't know if you know the answer to this, is Airbnb allowed by the strata corporations of all of these buildings that have been mentioned? Like, is it permitted?
So as part of our application review or audits for strata-related buildings, a licensee is required to provide authorization from strata. So if a license ends up being issued to any particular strata unit, either during a verification or during an audit, that would mean that we received the appropriate information and that the strata allowed at minimum short-term rentals in that unit, if not building-wide.
Okay, and that would come in form of a letter typically?
Yes, which is contained in this package.
Okay, great. That's all my questions. Thank you. Okay, now we will move on to the applicant and the applicant's counsel. So does the applicant or the applicant's counsel have any questions for the witness?
I do. Where would you like me? Like, can you hear me just fine? And is this
I'm
sit here, or do you want me to sit somewhere?
maybe, I'm not sure if you need to be in front of a microphone, or I would imagine for the live stream.
There's a microphone
If you
on
don't
this
mind
side.
just moving over to the right of Ms. Hicks. Thank you.
You see the one with the red?
So please go ahead when you're ready, Mr.
Craig.
Schrag. Thank you.
Ms. Hicks, correct? Ms. Hicks, how long have you been the chief license inspector?
I have been the chief license inspector since 2021. Prior to that, I was the deputy chief license inspector since 2014.
So do you have personal knowledge of the decisions that were made with respect to various units Mr. Lamore owned prior to becoming the chief license inspector?
Sorry, can you repeat your question?
So maybe I'll try this a different way. And you have the evidence package?
Yes.
Okay, you go to tab 2, please.
Yes.
And this is the timeline that my friend, Mr. Dixon, was taking you through earlier. Did you prepare this timeline?
My staff prepared this timeline.
Do you have any reason to believe this timeline is incorrect?
I do not.
Okay. So let's start on the, I guess it's page, I'll go with the page numbers in the upper right corner, just for consistency. I'm on page 4. 5 entries down. This is August 14th, 2020. Speaks to the issuance of a bylaw violation notice to Mr. Lamore in connection with 3207 689 Abbott Street. You see that?
I do.
So I'm going to refer to that as the violation notice or the 2020 ticket. So if I do, you'll understand what I'm referring to.
Mm-hmm.
All right. And then this next entry says August 17th, 2020. It refers to a license being refused at the same address. You see that? 3207 689 Abbott Street?
Yes.
Okay. And on what basis was that application refused?
I would need to look through the package in order to let you know.
Okay, can you look to page 30 at tab 3?
Yes.
So this is the refusal that's referred to that we just talked about. It was November 5th, 2020, correct?
It is, yes.
Right, and that was after Mr. Lamore had paid the violation ticket, correct?
It was.
And you'll agree with me that in this letter, which was drafted by Mr. Miyagi, you see that?
I do.
There's nothing in this letter about the violation ticket, correct?
Correct.
The violation ticket wasn't relevant to the city's refusal of this license application on November 5th, 2020, correct?
I think an error was made in not noting
Think
it
an
in
error was
this.
made? What do you mean you think an error was made?
I believe an error was made and it should have been noted in the package.
In fact, you have no personal knowledge of whether an error was made, correct?
It is my belief that an error was made, as it should have been noted as another rationale for refusing the license.
Okay, but again, my question was, you have no personal knowledge as to whether an error was made. You have no, in other words, you don't know why Mr. Miyagi did not bother to mention the license, the violation notice in refusing this application, correct?
I don't have the specifics of conversations around that time, no. What I can say is that staff typically try not to overload letters with multiple reasons, particularly in this case, since Mr. Lamore, I do believe, had canceled the application at this site.
Again, but you're guessing. You don't have personal knowledge of why this letter doesn't refer to the violation notice, correct?
I do not.
Thank you. Okay, I'm back at page 4 at tab 2. This is a useful aid memoir, so we can follow along. The next heading refers to April 3, 2020 to May 1, 2023. Do you see that?
I do.
And then the first sub-bullet, if I can call it that, says, received STR license application 2020-210025 for Wiria Lamore at 2908 688 Abbott. You see that?
I do.
So the license was issued after review. Do you see that?
I do.
So you agree with me that the license was issued and that at the time the chief license inspector had no concerns around the violation notice, correct?
No, I can't speak to concerns of the chief license inspector at the time. What I can say is that it was certainly an error in that the ticket should have been considered in the decision.
Again, you have no personal knowledge of whether or not the license inspector at that time considered the violation notice to be relevant, do you?
I can't say whether I was directly involved in conversations about Mr. Lamore at that time.
Well, do you remember those conversations?
No, I do not recall being involved in conversations about that particular license application.
So as far as you know, the chief license inspector may or may not have considered the violation notice relevant to that application, correct?
I believe that there was a staff error in not bringing this to the attention of myself at that time.
That wasn't my question. My question was, as far as you know, as far as you have personal knowledge, you have no personal knowledge of whether the chief license inspector considered the violation notice relevant to that application, do you?
I do not recall.
You don't recall or you don't know?
I do not recall.
So maybe you had that discussion, you just don't remember.
I don't recall.
And that application for a short-term license for 290868 Abbott Street was renewed in 2023, correct?
It was.
And you have no personal knowledge of whether the chief license inspector had any concerns around the violation notice.
She is the chief license.
Ms. Hicks, were you the chief license?
She was the chief license.
I've been the chief license inspector since 2021.
Oh, I see. So that in 2023, you renewed his license, correct?
So business license renewals are an automatic process where emails are sent to individuals where they can click a link, pay online, and print their license from home.
Right, so for in 2022, were you the chief license inspector?
I was.
Right, so you had no concerns when you granted the license 22-21-0025 for Mr. Lamore, did you?
No, I said that I did not recall having conversations about this particular business license application.
But you accept that if you had concerns, you had to deny it, correct?
Had staff brought up the fact that there was a ticket related to Mr. Lamore, I would have denied the license application.
Okay, so you're saying it was staff's fault that it wasn't brought to your attention?
I believe that there was likely a staff error related to Mr. Lamore's applications.
Let's go to the next page, page 5. We went through this, my friend took you through some of this earlier. This is the current application. Now, we'll skip ahead a bit. Mr. Lamore applied, and I'm about 3 items down, July 20th, 2023. It says a short-term rental license application, I won't read the number, was not supported for issuance on July 20th, 2023. You see that?
I do.
Okay, what that means is that you did not support it, correct?
Correct.
Okay. And then it says, a letter was sent to Wiria Lamore by email and registered mail outlining this decision, correct?
That is what that says, yes.
And that's what happened, correct?
I do believe it
And
did
I
happen.
believe Councillor Fry asked a similar question, but I want to just make it clear on the record. When you send those rejection letters, they are comprehensive, correct?
They provide information related to the decision at hand.
Right, but
They may not provide an entire historical accounting of all that has occurred with the unit or with the applicant.
that's not what I'm asking. What I'm specifically asking is that there, and I'll be clear, my question I accept wasn't as specific as it should have been. When a letter is sent, when you send a letter to an applicant refusing their application for this type of license, you explain in detail all of the reasons you are refusing the application, correct?
They may not contain all of the reasons, they do contain the key reasons.
Okay. And you would agree with me that refusing a license on the basis of a previous conviction would be a key reason, correct?
I do.
Okay. And you agree with me that your letter on July 20th, 2023 makes no mention whatsoever of the violation notice, correct?
I do.
You agree with me?
I do agree.
Right. The only reason given was that you were not satisfied that that unit, 703-188 Kiefer, was Mr. Lamore's primary residence, correct?
I would need to go look at the letter again to be certain.
Page 199.
Yes, that is the reason that is stated, that we do not believe that it is Mr. Lamore's principal residence.
And sitting here today, there were no other reasons in your mind and in your view to deny him the application, correct?
So I believe in this circumstance, there was an error, much as I discussed before, that staff had not brought forward the previous enforcement history and ticketing in order for it to be considered in this decision.
Yeah, but let's leave that aside. I accept your evidence that you didn't know about it. I don't doubt you. I don't doubt your sincerity. So leaving that aside, the only issue, based on the information that you had that was leading to the denial, was the fact that you weren't satisfied that this unit was his primary residence, correct?
At this time, yes.
Okay. July 20th, 2023. Okay. And then back on page 5 at tab 2, under there's the bold writing says January 10th, 2024. It says a meeting was held via telephone between Wiria Lamore and short-term rental staff. You see that?
I do.
Were you involved in that telephone discussion?
No.
Okay. Now, the transcript is, I'm assuming your office provided the transcript, which is at tab 11.
Yes.
Have you reviewed this transcript prior to this hearing?
Yes.
Okay. Do you have any reason to believe this transcript is inaccurate or contains material errors?
No.
Okay. Okay, let's go down a couple of, back at page 5 at tab 2. We go back down a couple entries. March 7, 2024, it says license application, I won't read the number, was not supported for issuance due to the totality of information on hand. What do you mean based on the totality of the information on hand?
When we're considering everything together related to an application, it is not believed that the applicant meets the requirements of the bylaw. In terms of looking at the prior history, the information provided during the meeting, where there, particularly in this case, where there are confusing dates that the applicant was unable to clarify, that in totality, we did not believe that they met the requirements of the bylaw.
The only reason you gave Mr. Lamour in your letter to him was the same reason you'd given to him earlier that year, which was that this unit, 703188 Kiefer, was not his primary residence, correct?
I would need to look at that letter.
242.
Yes, the rationale given was that in totality, we did not believe that it was their principal residence.
But you had no other concerns that would have allowed you to, at that time, deny him the license, correct?
With the information available to me, no.
Okay. But of course, at the time, you sent the letter at page 242, which is March 7, 2024. Staff was well aware of the violation notice, correct?
I can't speak to their current knowledge of the violation.
Well, Ms. Hicks asked Mr. Lamour at the interview in January about it, didn't she?
Sorry, no, I did not. I was not part of the interview.
Okay, no, I didn't say that you were part of the interview, but you were aware that Ms. Hicks was asking.
I am Miss Hicks.
Sorry. Ms. Hanson, it looks like if you look at page 226, the person that was conducting the interview, the principal person, was Michelle Hanson, correct?
Yes.
Ms. Hanson works for you, correct?
Yes.
You discussed this interview with Mr. Lamour before Ms. Hanson conducted it, correct?
Sorry, can you repeat your question?
Well, before Ms. Hanson and Ms. Ho interviewed Mr. Lamour on January 10th, 2024, you did discuss with Ms. Hanson the fact that she was going to be interviewing him, correct?
I can't confirm whether or not I had a conversation with Ms. Hanson about scheduling an interview with an applicant. I do not typically get involved in the scheduling of short-term rental audits.
All right. Now, this interview was conducted on January 10th, 2024. Do you see that?
I do.
And the letter that we just looked at 242 is dated March 7th, 2024. Yeah?
It is.
So in the roughly 2 months between the interview and your letter, you had a chance to review this transcript, or at the very least listen to the tape, correct?
I do not believe they're recorded. I would have had a chance. I did not review in detail these notes from the meeting.
Nevertheless, you do accept that Ms. Hanson was aware of the violation notice and discussed it with Mr. Lamour on January 10th, 2024, correct?
Apologize, I can't respond to that at the moment.
Okay, I'll try to help you just in the interest of time. If you go to page 236. And you'll let me know when you're there.
Yes.
So the bottom of page 2, well, 2/3 of the way down the page, there's a heading that says 3207-689 Abbott Street. Do you see that?
Yes.
All right. Mr. Lamour says, that's my mom's unit. Ms. Hanson says, do you live there? Mr. Lamour says, I moved there for a little while during COVID. Ms. Hanson says, did you ever STR that unit? Mr. Lamour says, not me, she did. I recommended that she did, it wasn't me. Ms. Hansen says, we do have a record of you applying for a license at that unit in August 2020. And before that, it was operated unlicensed. Looks like we sent you a ticket for operating unlicensed. You see that?
I do, yes.
And you were aware that Ms. Hansen had discussed this with Mr. Lemore before you wrote your letter on March 7th, 2024, correct?
No, I was not aware.
Why not?
I did not read the minutes of that meeting prior to the decision.
So when you wrote your letter on March 7th, 2024, were you aware of the violation ticket?
I was not.
Okay, but Ms. Hansen clearly was. You accept that, right?
I do.
Okay, so why did she know and you didn't?
I believe it was a staff error in bringing it forward.
So as of March 7th, 2024, and I think, I want to make sure I have your evidence clear on this. At that time, the only material concern you had that would have caused you to deny the license was the fact that Mr. Lemore was not using that unit as his primary residence, correct?
At the time, yes.
Okay. And so Mr. Lemore then reapplied, and I'm back at the bottom of page 5 at tab 2. Again, my friend Mr. Dixon took you through some of this. On April 15th, 2024, Mr. Lemore applied for another short-term license, correct?
Yes.
And in your denial letter, you make no mention of the fact that you had any concerns around Mr. Lemore not using that residence as his primary residence, right? Wasn't an
In the letter from June of 2024, is that what you're
Correct,
referencing?
June 18th, 2024.
No, in that letter, we only reference that he had the bylaw violation, and therefore I was required to deny it.
Right, but leaving aside that, I'm asking you, you didn't have any concerns around it not being his primary residence, because if you had, you would have said it, right?
Sorry, give me a moment. That in that letter, we only pointed out that it was the violation as we, with the additional evidence that we had received, we would have considered the issuance of a license to Mr. Lemore.
And so sitting here today, you have no reason to believe that Mr. Lemore is not using 703-188 Kiefer Place as his primary residence, correct?
We haven't gathered any additional evidence to indicate otherwise.
Right, but Mr. Lemore and I, on his behalf, provided you with quite a bit of information to support the fact that that property is his primary residence, correct?
Yes.
And you have not anywhere in writing ever said to Mr. Lemore since the earlier 2024 refusal that you had any concerns around that evidence, right?
I'm currently not aware of any concerns.
Well, you're the chief license inspector. Do you have the concerns or don't you?
I currently do not have the concerns.
Okay. So at the end of the day, but for the existence of a violation notice for a different unit in August of 2020, you cannot think of any basis to have denied Mr. Lemore his license, correct?
Correct.
Those are my questions.
Okay, thank you very much. We will now move on to opening remarks from the applicant's counsel.
Sorry?
Might want to vary, if we can just confirm, Mr. Schrag, you don't have any evidence, correct? With respect to, like, you're not calling a witness, correct?
I'm not calling a witness, no.
Right. So given that, I would suggest that perhaps the best way of handling this from now is that if I give my brief summary, as there's no evidence, and then Mr. Schrag can make whatever submissions he feels are appropriate, and if I feel a need to reply to any of them, and I suspect I will not, I can do that very briefly afterwards.
Okay, that sounds good.
And acceptable to Mr. Schrag, if that's...
That sounds perfectly reasonable to me.
Okay, great. So Mr. Dixon, please go ahead.
I don't have a great deal to add. You heard both in direct and in cross-examination that the chief license inspector only refused this license because of the 5-year requirement in the bylaw, which she is required to do. She has stated that had the application come in without that previous conviction, that she would have issued the license, and the license would have issued. So it is within the purview of council to, in these circumstances, to do it. So in the absence of you having any other concerns, you are able to issue that license, because that section of the bylaw does not apply to this panel. That's basically the circumstances as I see it on behalf of council.
Okay, thanks very much. Any response from the applicant, council?
Yeah, I'll just very briefly. It seems to me that the main decision the council has to make today is whether or not a 4+ year old violation ticket for a different property that was paid without complaint should act as an insuperable barrier to receiving a license that would otherwise have been issued. I think in my respectful submission, Ms. Hicks was candid by saying, but for the ticket, which she felt tied her hands, her office would have issued the license. That ticket doesn't tie your hands, and in my submission, it ought not to tie your hands. It was years ago. Previous license inspectors, and Ms. Hicks and her predecessor, Ms. Hicks, I gather, from 2022, issued a license to Mr. Lamore, apparently not realizing that the ticket was there. There appeared to be no issues with that license in 2022 and 2023. There were concerns more recently. The only material concern that the city staff had with respect to Kiefer, 703-188 Kiefer, was that the property was not Mr. Lamore's primary residence. It's the only concern they had. And that concern, given Ms. Hicks, I think, candid evidence, no longer exists. So in my submission, it would be punitive and unfair to deny Mr. Lamore a license on what, in my submission, is effectively a technicality. And that's all I have to say.
Okay, thank you very much. I know we jumped ahead a bit. We don't have any witnesses, right? Just to confirm.
Oh,
Yeah. Okay.
witnesses are complete. I think
Thank-
we're at
Closing
I know
submissions?
you're at discussion now.
Okay.
Unless any of you have any questions for either council.
Yeah, that's a good point. Council, do you have any questions for either of the speakers? Councillor Montague.
Yeah, I don't have any questions, but unless Councillor Fry does, I'm wondering if we could just have a 2-minute recess so I can draft up a motion to be discussed or debated.
Sure. Yep. I'll grant a recess. How about 5 minutes?
Sure, sounds good.
Okay, so we'll welcome back. We will now move to discussion by the panel. Panel members, if you'd like to make any remarks, please place yourself on the speaker's queue. And Councillor Montague, please go ahead.
Yeah, thanks, Chair. I was hoping to ask maybe some clarifying questions as well through you, and whether it's to the Chief License Inspector or the City's Council. I'll leave it up to you to decide. So the way that the city's bylaw is written is that if a violation notice has been issued, and the fact that it's been paid would insinuate a guilty plea. That requires you within the next 5 years to deny licenses. Is that correct? Just your hands are tied. You must follow that policy, that bylaw. Is that correct?
If there's a conviction related to the nature of the license at hand for the previous 5 years, yes, I have to deny the license application.
Okay. So my other question is had that violation not been issued, or there hadn't been a guilty plea in that violation, which was in 2020, right?
Correct.
Would you have issued a license for this?
We would have considered the issuance of the license, yes.
Okay. But not necessarily based on...
Looking at the information available to me, I believe that we would have issued it because the conversation turned to the conviction. I can't say that we, followed the entire history through to what would we do if. But looking at it today, I would say that we would have considered the issuance of the license, and that today, if Mr. Lamour, based off his counsel, does continue to be the principal resident, issuance is certainly a possibility. Yes.
Okay. And are you still concerned that this is not a principal residence?
I believe it was attested to today by his legal counsel that it is his principal residence. So I would believe that.
Okay. That's all I have right now, Chair.
Okay, thanks, Councillor Montague. I will just add myself to the queue here as well, just for a question to Ms. Hicks. You mentioned the bylaw conviction was in 2020, is that correct?
Correct, August of 2020.
Okay. So in 2026, Mr. Lamour could apply for an STR license?
In September of 2025, he could apply.
September of 2025. Okay. Okay, thanks for clarifying that. Appreciate that. Okay, so we will now move to a decision by the business license hearing panel. Would someone like to move a motion? Do we have more discussion? Oh, Councillor Fry, is that to move a motion?
Yeah. I've submitted to the clerk just now, actually. And yes, I would like to move a motion that the business license hearing panel uphold the decision of the chief license inspector to refuse the issuance of the business license to the applicant for a short-term rental accommodation located at 703-188 Kiefer Place on the basis that the city has determined in consideration of the totality of information, including past violations in history.
Okay, I've received that as well in my email. So thank you, Councillor Fry. And we have that up on the screen here. So I will need a seconder. Okay, seconded by Councillor Montague. Okay, all those in favor say aye.
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 Oh,
or do we just do
Councillor
record a
Montague
vote?
on the queue.
Apologies, sorry. Oh, Councillor Montague, sorry. Go ahead, Councillor Montague.
Yeah. And maybe it's a so I seconded the motion from Councillor Fry because otherwise we end up in a bit of a stalemate here. I'm a big believer that our chief licensing inspector has refused this license because of this specific point in the bylaw that says that she shall, rather than she has the ability to use discretion with regards to a past violation notice. So while I did second Councillor Fry's motion, somebody has to second a motion here on the floor, whether I disagree with it or agree with it or not. I will just say that I'm a little torn because while there is a violation and there does appear to be, when you do look at the totality of the information that was provided in this package, I do have some serious concerns. But I also have the chief licensing inspector saying that the short-term rental officer office would likely issue a license. So I just wanted to clarify that before we went to a vote.
Okay. Thanks, Councillor Montague. I will, do I need to cede the chair to make comments in business license hearing or no? Nope. Okay, thank you. I'll just make some comments as well. I understand that there was a staff error made. Unfortunately, mistakes happen, but in my eyes, that doesn't change the fact that there was a bylaw conviction within the past 5 years. That did occur. It's unfortunate again that that error was made by staff and it wasn't acknowledged in the correspondence to Mr. Lamore. But again, it doesn't change the fact that there was a bylaw conviction within the past 5 years. And as we heard, this operator will be free to apply for a new license in the later half of next year. So I am also in support of Councillor Fry's motion. So we'll just do a simple vote here. No need to record it. So all those in favor say aye. Aye. Any opposed?
Opposed.
Okay, Councillor Montague opposed. So that does carry with Councillor Fry and myself in favor. We need to do a recorded vote. Okay. So we're just going to do a recorded vote. So just a moment here while we get the panel up. Okay, so again, we just did a recorded vote for that. So Councillor, myself and Councillor Fry in favor and Councillor Montague in opposition. So that motion carries. Okay, and that's our decision. Thank you. Moving on to our next item. The last item on the agenda is to consider the decision of the Chief License Inspector to suspend the 2024 business license issued to Igor Sharapova, the licensee, for a short-term rental accommodation at 903-180 East 2nd Avenue, the premises. Okay, one moment here. Thank you. Okay, so we'll now start with opening remarks from Ian Dixon, Counsel for the City of Vancouver.
Chair, Ms. Sharapova, if you could just come forward so that this is Ms. Sharapova, who's the applicant or the business license holder. She's here on her own. She's not represented. I'm not going to reiterate your powers under the charter for the purpose of this, but I will explain exactly what brings you to this. You can sit down, Ms. Sharapova. So this application in this scenario is quite different from the one that you just heard. This one relates to section 28.1 of the license bylaw. And this section 28.1 of the license bylaw states that, at subsection 7 says that before applying for a business license, a short-term rental accommodation operator shall A, obtain strata council authorization if the short-term rental accommodation is in a strata lot, and B, obtain authorization from the owner or landlord if the short-term rental accommodation operator is a tenant. And then further at subsection 14, a short-term rental accommodation operator shall provide documentation or records that demonstrate compliance with this bylaw to the Chief License Inspector upon request, including but not limited to sub B, proof of strata authorization if the short-term rental accommodation is or is in a strata lot. And I just note that as a new license has to be applied for each year, the requirement for section 28.1 must be satisfied each year. And it is the practice of Ms. Hicks will tell you, it's the practice to request a new strata council authorization each year. So I'll just, this is a scenario in which Ms. Sharapova had a Strata Council authorization in 2022, but it appears that she will tell you that there's been no change in the Strata bylaws, but the Strata Corporation is now refusing to provide a new letter. So as there is no letter, that puts the Chief License Inspector in a different position because she doesn't have an up-to-date letter, and under the bylaw, that's a requirement of issuing the license. It'll be my submission at the end of just to frame this, that the main issue here is whether or not this panel considers that 2022 letter to be sufficient to meet the bylaw requirements. So I'll just go over to Ms. Hicks, go to Ms. Hicks's testimony. So
Great,
Ms.
thank
Hicks,
you.
If you can just go to tab 2 of the binder. And this is the timeline of events. If you just run us through the timeline of what's happened with Ms. Sharapova's license.
Certainly. Ms. Sharapova held a license in 2022 through a license verification process. We did receive documents satisfying the requirements of the bylaw, including a Strata authorization letter that was ultimately issued in November of 2022. In early 2024, we began receiving complaints related to the unit in that no Strata authorization was issued to the unit. So we began an audit notification process. Through that, we did receive, documents which would satisfy our need to determine Ms. Sharapova as a principal resident. However, a Strata authorization letter was not received. We understand that the Strata is refusing to issue a letter to Ms. Sharapova in that regard. So therefore, Ms. Sharapova did not meet the requirements of the bylaw as no Strata authorization was received, and the license was therefore suspended.
Just take you to, so there was a previous letter issued, is that correct?
There was, yes.
That is, just for the completeness, I've just lost it here, it's in the page 33 of tab 6.
Yes.
That's the letter that we received. I'll just note for the council that that's an October 31st, 2022 letter from First Service Residential, which relates to the Strata unit question.
Yes.
Okay, those are my questions.
Okay, thank you. I understand the owner doesn't have counsel. Does the Ms. Sharapova have an opportunity to question Ms. Hicks? So just
Normally do council members first if there's any council.
okay, so go to council questions. Thank you. Okay, so panel members, if you have any questions for the city witness, please place yourself on the speaker's queue, and I see we do. So Councillor Fry, please go ahead.
Right, so, and I appreciate that the Strata permission is inherent to the short-term rental bylaw, and it's an unfortunate situation. I'm familiar with this building. I just looked at it on the Google Maps, and I go by this every day on my way to work. It's a pretty new building, and, in 2022, it was literally just occupied, I believe. Is that?
I apologize, I don't have that detail.
Right, so has the Strata, are we aware that the Strata structure has changed since 2022 to today, notwithstanding the complaints that they've received? Is there, I guess where I'm going with this is it's such a new building. Was there a fulsome Strata that approved it in 2022 versus now where it's more occupied by actual residents? Do we have any eyes on that, or is this strictly the same management company?
I apologize, I don't have details on when the Strata would have been formed. First Service, I do understand, continues to be the property manager on site and would typically be the one acting on behalf of the strata to provide letters, although in this particular circumstance, direction from strata has been provided to the property management company to not issue any letters.
Okay. And
If it assists, perhaps I'll take you to, if you could go to tab 6. Sorry, page 53, 52. This is the strata bylaws provided by Mr. Makova. You look over on the next page, page 53.
yeah,
So we have a registration developer, and then there was amendments on the 1st of August 2023 and on April 17th, 2024. It doesn't say specifically when it was first started. There's also a in here, there was a special general meeting held on Thursday, June the 13th, 2024, which is at page 84. And there are a number of motions that were discussed and dealt with there with regard to short-term rentals. The upshot of that, I can inform you, having read them, is that nothing was changed between those dates. So I just add to the panel's attention. So perhaps that might help.
okay. So I guess back to Ms. Hicks, do we typically request a letter each year for renewal? Is that how this would work? Or is it?
No, during the renewal process, it is a straightforward renewal if there are no concerns at a site where the majority of businesses receive notification that their license is up for renewal. They're eligible to typically pay for that and then print a license from home. Where there are concerns, particularly at a renewal time, we can hold that back and go back through application documents to ensure that they meet the requirements of the bylaw. This particular case was brought up for an audit, which is separate from renewal process in its entirety. It was brought up for audit because of the complaints related to not having strata approval.
Right, and the complaints were not from the strata per se, but from other neighbors?
The complaints were from the building. I'm not sure the detail of which I would be able to release the context of the complainant.
Okay, fair. Lastly for me, and obviously you weren't writing the bylaw when but why do we have strata permission baked into the short-term rental bylaw?
It was brought up because of a number of concerns. Certainly when setting up short-term rentals, in terms of the regulations, we came into these regulations with a significant period of illegal operations, citywide. At that point, and strata authorization is incredibly important in these buildings. They are firsthand knowledge about what's happening. They all have rules about how properties are to function, and are certainly key partners, in ensuring that short-term rentals are done legitimately. We do not interpret short-term or strata bylaws. Staff do not interpret other individuals' bylaws. That information can have, conditions on approval. If this or that is met, then you can or you can't. Therefore, to make it as simple and as straightforward as possible for all involved, it is to provide strata authorization for a unit.
Thank you.
Thank you both. Councillor Montague.
Just continuing on those lines of questions, Sarah. So the 3 complaints, over how long of a period of time were those 3 complaints made?
3 months.
3 months? The recent or?
Of this year, May to July of 2024.
Okay, all 3 were within that time. Okay. I'm assuming that the reason we require, and you started to get to this, was require strata councils to provide a letter is if there's a short-term rental that is operating, that is problematic or causing disturbances to the building or to neighbors, that the strata has the ability to say, to not endorse or not provide that letter. Is that That be a correct assumption?
They could, stratas have a lot of authority, within their complexes of how their units are operated. Those letters are, to be clear for staff that this is allowed to operate or it is not allowed to operate. We also know that many different stratas, regulate that use of short-term rental in different ways. Some allow it per year with a fee. Some need internally themselves an approval every single year. So ensuring that it is up to date and current is important for us to ensure that it continues to be legal.
So the city doesn't care whether or not the building allows it. It ultimately comes down to a letter provided by the strata to say that a particular unit is permitted.
Yes, that the applicant at hand is permitted, yes.
Okay. I know you can't divulge who the complainant might be. Are the 3 complaints all from one source, or are they multiple sources?
From the same source.
Okay. Thanks, Chair. I think that's all I have for now.
Okay, thanks, Councillor Montague. So I will now move on to licensee questions for the witness. So does the licensee have any questions for the witness? And we'll just...
You can stay there,
We'll turn your microphone on, Ms. Sharapova. Just one moment here. Actually, if you don't mind just moving a little bit to the microphone with the red light. And then please go ahead when you're ready.
Well, the questions will be more about the...
If you don't mind just speaking into the microphone.
Okay. The questions will be more about the process, not necessarily decision, because I understand the decision. And I believe the Councillor Fry asked the question, but I just want to confirm that. As per the evidence package, you can see that I had a phone call with one of the staff, with Alexandra Holmes, on October 2nd. And during that call, I did ask a question because I wanted to confirm that, in fact, I did not miss or misunderstood something. And the question was, did I require to obtain up-to-date authorization letter every single time I applied for the renewal? So is that something I overlooked at the time? And she did mention to me that, no, it's not required, but what I am required to do is to provide that letter upon request from the Chief Inspector Office or from the office, which I believe you confirmed. But can you please say if that is the correct information?
So just to reiterate, during renewal, we do not require a new authorization each year. During the initial application, there was a valid letter provided. After receiving the complaints that no strata authorization had been provided, we began the investigation and the audit in which we requested a current or up-to-date letter of authorization for the unit.
Thank you. And the page 28 of the evidence package has the audit notification letter, which asks...
Ms. Sharapova, sorry, you just need to speak
cannot
into the
hear me.
microphone.
Okay.
I can barely
Okay.
hear you.
So page 28 of the evidence package has the audit notification letter, which asks for, it's now listed under number C, a letter of authorization from the strata councillor or authorized agent of the strata councillor at this premise, printed on official letterhead confirming that short-term rental accommodation are permitted on the strata lot. And the page 33 of the evidence package has a sample of the letter. And that letter specifies, please be advised that on behalf of the councillor for EPS 7697, 2nd and May, at this short-term rental accommodation are permitted for the strata lot, but this permission is subject to the building bylaw changing at a later date. Based on that, would it be a fair statement that the purpose of the letter is for the City of Vancouver to confirm that the short-term rentals are permitted on the strata lot, and this is how City currently verifies that information?
Can you repeat your question?
would that be a fair statement to say that the purpose of the letter is for the City of Vancouver to confirm that the short-term rentals are permitted on the strata law, and that is how City verifies that information?
It is fair to say that the strata authorization, yes, gives us information that the particular unit and/or individual is permitted to conduct short-term rentals. The letter that you pointed out in page 33, though, was written prior to the complaints received this year, saying that there was no strata authorization.
Yes, and I know that. The letter I pointed out is just to see what is the sample, like what is the wording on the letter which is required, or what would the letter be look like?
This is certainly an example of what a letter could look like, yes. We receive letters of all sorts of different information contained.
Is that true that in British Columbia, strata bylaws govern the use of the property in the strata corporation? And strata corporation can, in fact, create a bylaw by a pass of 3/4 of the vote of owners to limit or to ban short-term rentals. However, the bylaw amendment must be registered with the Land of Title Office before they take in effect.
I apologize, I can't comment on the Strata Bylaw Act.
Okay. Would anyone else know who governs the use of the property in the British Columbia? If I ask the panel if they have a knowledge.
It's not really the way the process works here. At this point, you're just supposed to be asking questions of Ms.
Got that.
Hicks. If she doesn't have any answers, you'll have the chance to make a submission. Generally speaking, though, the answer to your question is quite complicated. There are a number of different, both the city and the province regulate the manner in which properties are used, not just through the strata property.
Okay. So I will ask that question. I'm not sure if that would be similar to the previous question. The page 3 of the evidence package states that the chief license inspector has suspended the business license as the licensee was not able to provide the city with documentation to confirm that the strata counselor of the applicable strata plan authorized short-term rental of the strata lot. What I'm trying to confirm here, when I was reviewing the responsibilities of the strata counselor, it seems that the main responsibility of the strata counselor is to inform the strata bylaws that they don't have a power, let's say, to authorize short-term rentals if by law restricts it. Neither do they have a power to restrict short-term rentals when by law allows that. So technically speaking, the strata counselor, when issuing those letters, will confirm what strata by law allows in terms of the short-term rental in that building. Is that correct?
The difficulty here is you're asking Ms. Hicks, the reason why the city asks, as you heard from Ms. Hicks's response, the reason why the city asks for strata letters is so that we don't have to answer the question you just asked.
Got that.
Right? The city doesn't want to be interpreting the Strata Property Act or the strata bylaws. So in order to avoid us being involved in that, the city being involved in that, the bylaw is constructed to ask for a letter. That requirement's there exactly for the reason so that Ms. Hicks doesn't have to figure out who's able to write the letter, what the letter's based on, or any of those things. That's exactly why the letter's asked for.
Got that. Since the current bylaw asks for the letter from the strata counselor, which involves a third party. And when the licensee have a difficulty of obtaining that information with no fault of their own, but because they are cooperating with uncooperative strata counselor, what options or alternative does licensee have?
Because the bylaw is clear in what the requirement is for the strata-related component, it would be a civil matter between an applicant and the strata to resolve.
So that would be between an applicant and the strata.
Yes.
When on a page 4 of the package mentions that I have received 3 complaints, noting that I have no strata authorization, would it be possible to ask for the dates of those complaints?
I don't have the dates specifically on me today. They were between May and July.
Would it be fair to say that those complaints are the reason why I was selected for the audit?
Yes.
Is that true that your office is aware of the situation at 180 East 2nd Avenue, Vancouver, not only through my case?
What situation do you speak of?
That the strata counselor are refusing to authorize letters?
Yes.
Don't have any further questions.
Okay, thank you very much. Did you have any opening remarks, Ms. Sharapova?
I don't, but I would like to call myself as a witness.
Okay. Yep. Please go ahead.
I would like to, is that okay if I stand?
We can switch the microphone, yep, to the podium. You can move the microphone closer to your mouth as well if you need to. It's flexible.
Well, first of all, I would like to thank everyone for their time today. I do understand it's a long day and it's second hearing, so thank you for this opportunity for allowing me to present here today. And I would like to acknowledge that I'm not questioning the decision which is the Chief Inspector Officer made, because the licensing bylaw are very clear what is required for me as a licensee. So I was debating if I should even come and present in front of this panel. However, I have decided to come and present to this panel just to showcase, as an example, that the way the current bylaw are written, they do put licensee on a challenging situation where they're not able to obtain a certain information required, not fault of their own, but because they are dealing with the strata counselor that might not be cooperative. And I just want to see if the panel would find it reasonable. So I would like to start my case by addressing the complaints I have received about the unit that I do not have a strata authorization letter on file to operate the short-term rentals. I would like to mention that as a strata owner, I not only need to follow the provincial City of Vancouver bylaws, but I also need to follow a strata bylaws. And as Ms. Dixon mentioned, the strata bylaws can have a stricter requirements than the City of Vancouver does. On the page 88, number D, that is a proposed resolution. That resolution was not passed. But what the proposed resolution specifies, an owner must not use their owner strata lot for short-term rental accommodation without the prior written permission of the strata councillor issued on an annual basis. Both written permission from the strata councillor and licensee from the City of Vancouver and license from the City of Vancouver are required to use a strata lot for short-term rental accommodation. So if that resolution would to pass, I would need to have a separate strata approval as a strata owner to operate the short-term rentals at the building. But it did not pass, and you will not be able to find any reference of such requirement on the current strata bylaw, which were also provided in the evidence package. So as of when I was operating the short-term rental, in my unit, the requirement was for me to have a city license, which I did have. So I will not sure on what basis those complaints were made. However, the complaints are not a concern if I'm able to get that authorization on a later date. And I just want to walk you through the timeline of the events. On a July 9 is the first time when I can see that the strata councillor decided not to issue any letters to our strata owners upon their request. It's mentioned on the evidence package provided that the complaints which were received for my unit were somewhere from between May to the end of the July. So it's potentially, and again, I'm speculating that the complaint were made after they already made a decision not to issue any authorization. When you do look at the information presented to you, you can speculate, and again, I'm speculating that in order to be able to make a complaint that I don't have a strata authorization, you will need to have access to that information. So it's most likely would be that you would be a strata yourself, or you would be a part of the strata councillor. As a result, I received the audit, which I personally had zero concerns when I received the letter, because I thought I will be able to collect all the information very quickly. And the reason I was so confident I will be able to collect that information, in the part of the evidence package, I have provided the strata meetings of the special general meeting we had when the strata proposed to ban or proposed to regulate the short-term rentals in the building. None of this resolution passed. So because I knew that the resolution did not pass and the short-term rentals are still permitted in the strata lot, I did not expect to run into any problem getting that authorization. The audit prompted me to contact the strata councillor for the letter, and that's when I first time learned that they made a decision of not issuing such letters to the strata owners. That decision made me to reach out to the lawyer. I do have access to the lawyer helpline through my insurance company, just to learn what options do I have, and if strata corporation can, in fact, refuse issuing of such letter. During that conversation, I have learned that, legally speaking, strata corporation, in fact, are not wrong, and they are not required to provide me with such letter. Is that reasonable or not? It's a different question, but legally speaking, they are not required. And that's when I asked what would be my options. And he educated me of how it's the strata bylaws that governs the use of the property, and the strata bylaws would always be the source of the truth to confirm what is allowed in the building, and he recommended that I submit that as alternative documents. And I did that. I provided the strata bylaws as the alternative documents and the strata meetings, and one of the strata meetings did confirm that the letters were still issued prior to the special meetings, and they noted on that email correspondence with the staff when the audit was conducted, that at that time the letters were still issued, and they did confirm that the short-term rentals are permitted on the strata lot. And I also attached the special meetings from the strata meetings from the special meeting that no bylaws were passed to regulate or to ban the short-term rentals. I was advised at the time that that's not the information City is seeking, but since I wasn't able to get the information as asked, I asked for that to go to the Chief Inspector Officer, which led to the license suspension on September 27. When I mentioned that I would like it to go to the Chief Inspector Officer, at that time I thought it would open a discussion, open a communication, and open that they would look into like why I'm not able to provide that information. But later on, once I learned more about how the process works, I realized that was a wrong expectation of me, that the city bylaw is very clear what is required from me, and that it's unreasonable to ask City of Vancouver to do an extra work or verify that information by any other documentation available to them. But I did not know it on that time, and I was very worried to have that suspension record on file. So that's why I reached out to Alexander Holmes, and I had a conversation on October 2nd where I wanted to confirm if I did because one of the audit was one piece of the audit, they were asking me to provide the up-to-date letter of 2024, which I did not have on hand. And I wasn't able to get it because the strata council are refusing to provide one. And that's what I asked Alexander Holmes to confirm if I did in fact failed and I did maybe misunderstood the bylaws, that I was required to have and apply for that prior applying for the renewal. And Alexander Holmes confirmed that no, it was not required. I do not need to have that on file at the time of the renewal, but I have to be able to provide that at request. But that would be why I did not have one until I was selected for the audit. On October 8, I requested the strata hearing and I presented my case. The way the strata counselor work, the typical size of the strata counselor is 3 to 7 people. And you don't need to have any education or qualification to be on the strata counselor. So when I was presenting the case, I really felt I could reason with them because I thought perhaps strata counselor does not understand what kind of impact does that decision have to the strata owners seeking the license from the city. So I thought if I explained to them that my license was suspended because I wasn't able to provide an up-to-date letter, that I'm not able to operate the short-term rentals without the license, and that I do need to have that license in order to reinstate the business license. On October 16, I received a response from the strata, which also included a lawyer's letter. The lawyer's letter is attached to page 132. And the lawyer's letter specifies that the strata corporation is not obligated to provide a letter to a strata owner seeking a license from the short-term rental, or for the short-term rentals from the city, which basically means that strata counselor were aware of the impact it has on the strata owners. I do, however, would like to present their response because it's a part of the evidence and read some part of it. So the response is, it is an answer, email response to the strata hearing. So that would make it a formal communication. That response is approved by the strata counselor, and it is dated October 16, 2024. So it is recent. And it says, and it's on page 119. Council advice. Although they can't restrict your Airbnb by bylaw or other, they are not required by the Strata Property Act or by the Strata bylaw to provide you with a letter. A reminder that during special general meeting or resolution failed, resolution to ban short-term rentals, resolution to regulate short-term rentals, and even resolutions to follow municipal bylaws failed. You referenced the short-term rental during hearing, but you referenced to a short-term rental act during your hearing, but the Strata Corporation is not governed by the Short-Term Rental Act, by the Strata Property Act, and your Strata bylaws. So they are not saying, no, you cannot do an Airbnb, but they're saying we have no obligation to write you a letter. They also permitted me to provide the evidence, which was legal opinion under Clark-Wilson retainer. I would like to mention that this is new to me, so I'm not very aware of the processes. But later, when I watched some of the videos of the similar hearing, that's when I realized none of it is the City of Vancouver concern. None of it is a problem of the city. So what I need to focus on, what is the strata, what is the licensee bylaw is asking for me, and what am I doing in order to be compliant with that licensing bylaw. The licensing bylaw clearly specifies that I need to provide the authorization letter. What options do I have as a licensee? As we learned through the cross-examinations, the only options I have is to deal with it directly with to dispute that directly with the strata. So what I have done, I have submitted a claim, which is also provided. It's on page 128, and that's a claim through the BC Tribunal. So that's basically a legal process when I'm challenging their decision of not issuing the letters to the strata owners. However, why I'm here today is there is a letter on file dated dated in 2022, which I would like to read again what it says. It says, please be advised that on behalf of the counselor for EPS 7697, 2nd and Main, at this time, short-term rental accommodation are permitted for this strata lot, but this permission is subject to the building bylaws changing at a later date. There is a letter from a strata manager, also approved by the strata counselor, which specifies that resolution failed. So resolution to ban short-term rentals failed. So I would like panel to see if it's reasonable to accept that as a confirmation that the building bylaw did not change and the letter I have on file is still in effect. And that the panel would see that I am taking all options available to me to sort this with strata counselor, and I will be able to provide a letter of authorization at the later date. But at this time, if the evidence presented, including including the current strata bylaws, and the strata bylaws, if there are amendments, they are filed with the land title office. So although not required, city does have access to that information, so it can be confirmed if the strata bylaws in fact changed. Although I do not expect city to do that, that's why I provided that letter from the city, from the strata and the strata council to confirm that the bylaws in fact did not change. And that would be all for me. And thank you again for your time.
Okay, thank you very much. Panel members, do you have any questions for the witnesses? Councillor Fry, please go ahead.
Yeah, so I've looked through this and I was trying to find some more details on your strata plan, which some of the sources say that it is short-term rental approval with council approval, or short terms with council approval. But without getting into that, because it's just the internet, reading these minutes, it's clear that where it needs a 3/4 majority, there's 3 different motions at the strata plan. And the majority of the voters wanted some kind of short-term regulation, but didn't meet the 3/4 threshold. So I'm assuming that that's a change in the dynamic of the strata. Was this building, the original strata plan was prepared by the developer, I understand?
That's a great question. Can you repeat that question again?
So your original permission was under a strata plan that was approved by the developer, yeah?
My understanding, yes.
Yeah, yeah. And then since then, new strata plans and more residents. And I mean, it does put us in a very difficult position because the bylaw is pretty clear that we need the approval of the strata. And it seems to me that your issue is with the strata and the 3/4 rule and the various permutations of your strata bylaw that have very little to do with the City of Vancouver, because at the end of the day, our only requirement is the permission of the strata, which we are not able to secure for this license.
So you're referring to the minutes, which is part of the evidence. And on the minutes, they did not reach the 3/4 of the voters. So majority was against putting any regulations and against putting any restrictions, actually against banning it and against strata regulating it. So they did not meet that. So that means the bylaw didn't change.
It didn't meet the 3/4, yes.
Yes.
The majority was.
I completely understand. But if you look at the licensee point of view, I need to follow the provincial rule, I need to follow the City of Vancouver rule. And right now, of not fault of mine, the current bylaws allow the short-term rental accommodation.
No, I completely understand, but without that permission, physical permission from your strata that the City of Vancouver can hold against your license, our hands are tied.
Yes, but I do have a permission. It is, so for example, so I have a permission which is October 2022, which says subject to the building bylaw changing at a later date. And I hope the evidence I presented is enough to satisfy that the bylaws did not change. For example, if you and me go in an agreement of renting an apartment, and that's basically an authorization, a permission, I'm not going to renew that rental agreement with you on an annual basis until things change. So I do have a permission, and I hope that this is, because the bylaws did not change, it could be accepted. And also, it's not directly, it's not on official letterhead, but I also have a letter from a strata councilor which specifies that they're not saying, no, you cannot do the Airbnb. They're saying they cannot restrict the Airbnb. They just don't want to issue the letter.
But unfortunately, as you realize, our requirements are the authorization, which we're not able to achieve currently. But okay, no, and I appreciate how this is frustrating for you, and it's a difficult situation to be put in. Thanks.
Okay, thanks, Councillor Fry. Councillor Montague.
Thanks, Chair. Actually, my questions aren't for this witness, but for clarifying questions to either our city council or chief licensing inspector.
Please go ahead.
So can you confirm in the bylaw?
Questions of Ms. Sharapova?
I believe so, unless council has any more questions for the applicant or the licensee. Oh, okay, so we've concluded questions to Ms. Sharapova, and now Councillor Montague, you may ask questions for me to our city's council.
Thanks. Can you confirm, so with this specific short-term rental, we're looking at an infraction under section 28.1 of the bylaw?
Correct.
And it's 28.1, I'm assuming it's 28.1 sub 7 and sub 14?
Correct.
Okay, so does it actually say in there that we're required continued permission for specific units, or just that it's the strata authorizes short-term rental within the building? My read of it is that we require authorization from the strata that it's permitted within the building.
That's correct. It's not, there's nothing in this specifically, there's nothing in the bylaw specifically which states that it has to be a new letter on when it's asked for, or when the letter's applied for. It's the practice, as I understand it, of the Chief License Inspector's office to request an up-to-date one so that they don't get caught with a scenario in which the bylaws have changed or the like, in order to ensure that they have consistency. So that's their practice, is to ask for an up-to-date one. But I don't read the bylaw as saying that there's anything preventing, and in particular this situation, you as the panel here looking at that letter and concluding that that satisfies 28.1 sub 7 if you wish to conclude that. The Chief License Inspector's office has made a decision that for the purposes of an ongoing basis, in order so they don't have difficulties, that they ask for for new ones and they reject older ones. But it's not, that's a decision that they've made for their purposes. The bylaw and that decision doesn't bind you as council. It's something that the Chief License Inspector uses as a guideline for herself.
Okay, and for Ms. Hicks, I think is, so that was my interpretation as well. So thank you for that. So June, when was the date this was application was rejected?
It was actually not rejected. It was a suspension based on the complaints.
And what date? Sorry, what date was that again? I'm just looking through was August.
September 27th, notice of license suspension sent to the applicant.
Okay. And the audit was through August and September.
Correct.
Did the applicant provide the minutes to the June 13th strata meeting? With regard, when it's in the package, I'm wondering.
It is, yes. So it was all provided as part of the information.
Okay, and was that used during the decision, or was it a decision by your office to not try and interpret the bylaws?
Correct.
To just.
Correct. And because the bylaw is so clear in what's required, we did not interpret the minutes or the meeting that the applicant provided. And further, because of the complaints received, that strata authorization was not in place for the unit.
Okay. I think that's all I have for now, Chair. Thank you.
Hey, thanks.
I'm sorry, Chair. The applicant has just asked if they're able to ask another question.
To the City Council or to the Chief License Inspector?
Based on a follow-up.
Okay, yeah, I'll permit it. Please go ahead. We'll just turn your microphone on.
Yeah, that based on the follow-up. So this strata authorization letter, they're more acting to get a confirmation that it's allowed on a strata lot, correct?
We'll get that on. Go ahead.
So the letter that we are looking to receive is that it can either state that Strata, authorizes the unit. We are looking for the unit, or yourself specifically, that short-term rental is permitted, or that it is not, banned in that particular unit.
The decision by the Strata Council not to issue the letter was made on July 9. Does city has letters on file dated 2024 for this building acknowledging that short-term rentals are permitted?
Sorry, that's not information I have available to me.
Thank you. I don't have any questions.
Okay, thank you very much. Okay, so does city's council have any questions for?
Sorry, Chair, I was just,
Yes, Councilor
sorry to interrupt.
Montague. Yep, go ahead.
I saw it, I noticed my clock was still going. I did have a little bit of time left. I'm wondering if you can indulge me with just one more question.
Of course, yeah, sorry about that. Please go ahead.
And there's no time restrictions on this hearing.
Great, thank you. The 3 complaints that were received by your office, did they provide any information beyond that there was no permission granted? Or did it actually provide indication in the strata bylaw with minutes that show that the strata no longer authorizes it?
No, the complaints were of the nature that the particular unit did not have strata authorization.
Okay, so nothing specific in providing an update and change of strata bylaws or any of that?
No.
Okay, thank you, that was my question.
Okay, thanks, Councilor Montague. Excuse me. I'll let Councilor Fry go, and then I'll go after. Go ahead.
Yeah. More just for a general kind of context and color to this, how often does your department receive complaints from stratas or withholding of licenses as at the request of the stratas? Is this a fairly common occurrence, or?
We regularly receive correspondence from stratas and landlords, about units not being authorized to operate with short-term rental. I think the unique issue at hand here is one that I'm, not very common with, is that the strata is refusing to issue letters. That is the fairly unique, in this circumstance. It's not something that we've seen before.
No, I mean, and totally understand the complexity and the tension here over the fact that technically it is legal under the strata bylaw, but the strata council is refusing to issue the letter. Do you think moving forward, and obviously we're not going to amend this on the floor right now, that might be an area we should improve our short-term rental bylaws, or I guess it's 4450 under the licensing, or is this just such a rare anomaly that we don't have to?
I think this is a unique circumstance.
Okay. Right. Thank you.
Great. Thanks, Councillor Fry. And I had a question for Ms. Sharapova. I heard you mention Civil Resolution Tribunal.
Yes.
Can you just clarify, you did launch a case there. Was that concluded, or is it still in progress?
No, it's still in process. I have submitted the claim, and what I learned through the process, you cannot cancel it, or you cannot revoke it. So it will be a go. It will be processed. The timeline on that was specified is 2 to 3 months. It will take to have the process completed. So I hope, but at the end of the process, I will definitely be able to provide an updated and additional letter. But at this time, it's in process.
Okay, thank you for clarifying that. That was my only question. Thank you. Okay, does City's Council have any questions for witnesses?
Do not.
Okay, thank you very much. And now we'll move to, do you have any closing submissions, Mr.
I
Dixon?
would just like to make a brief closing submission. Just remind the panel, and I think it's well understood that the panel, unlike council, is bound by the terms of the bylaw. So what you're doing, what your role is here in these business license hearings is to apply the bylaw. I mean, in the one that we heard earlier this morning, of course, there's a difference in the authority between between council and the chief license inspector. In this instance, there's no difference in authority between the two of you, between the chief license inspector and the business license hearing panel. So you are bound by section 28.1 of the bylaw. However, in fairness to the applicant here, as I mentioned to Councillor Montague, there is a road by which you could consider this approvable by considering that letter from the 26th to still be valid, because it doesn't state in the bylaw when there is no time limitation in the bylaw with respect to that, but that is a practice that's developed at the chief license inspector's office, and it's a practice that's developed for very good reasons, but you're not bound by that practice.
Okay, thank you very much. Any closing submissions by the licensee? That'd be you, Ms. Sharapova. Actually, if you just stay where you are.
Yeah.
Thank you.
Sorry. I don't want to take a lot of time, and I just want to thank and that I would appreciate a panel looking into it. And one of the other comments I would like to make is, you can see that I had a license since 2022. I only offered the short-term rental accommodation from mid of May till July this year. And that's when the complaints were coming. The reason for it is because I'm currently on maternity leave, so I am able to be away for extended period of the time. Because one of the questions would be that I have a process claim with the BC Tribunal that eventually I will be able to solve this with the strata counselor. But I'm here in front of this panel today is because I don't, as a licensee, have too much of the opportunity when I'm able to offer this on the short-term accommodation at the unit, and this is why I'm here. I completely understand what is the requirement from me at the city bylaws license, and I hope you can see that I'm taking all the efforts which are available to me to satisfy that. But while I'm working on getting more recent letter from the strata counselor, I would like to see if the panel would find it reasonable to accept the letter I have on file, which specifies that it's in effect and until bylaws change, and I hope the evidence in the package are able to confirm that bylaws did not change. Thank you so much for the time.
Okay, thank you for that. We'll now move on to discussion by the panel. Panel members, if you'd like to make any remarks, please place yourself on the speaker's queue. Councillor Fry, please go ahead.
Yeah, I am sympathetic to Ms. Sharapova. However, it is a tricky situation given that even to make an exception on this one case potentially sets a precedent that is complicated to unravel because strata bylaws will change in other buildings that have short-term rentals or not. And we have a pretty clear requirement under 28.1 to supply that authorization. It seems very clear to me that Ms. Sharapova has an issue with the governance within her strata council, but that's not a City of Vancouver issue per se. That is something that you're rightly pursuing in another legal avenue, and I encourage you to do that. I do believe that as far as precedent goes, though, our hands are tied because we are obliged under our own bylaws and our own short-term rental regulation that this is our practice, and it's an awkward situation for sure, but that is our practice. And I worry that even if we were to try and make some kind of exemption for just this one case, it would create a precedent that would be unsustainable for future investigations for our hardworking short-term rental team that do a lot of this work. And I appreciate that they're also sympathetic, but I think that our hands are sort of tied on this. And I am going to submit a recommendation that we uphold the decision of the chief license inspector on this one.
Okay, thank you, Councillor Fry. I put myself on the queue as well. I'm also sympathetic to your situation. I am glad to hear that you're going through CRT. I've been through the process myself, and I hope that you get the outcome that you're looking for. But to Councillor Fry's points, this really could open a can of worms for us if we were to make an exception. We have a lot of STRs in the City of Vancouver, and it really is paramount that we are able to have an updated letter upon request. So that to me stands out. And again, just sorry to hear you're dealing with a strata that's uncooperative. That must be extremely frustrating. And I hope you can get it sorted out. But I will be supporting Councillor Fry's motion. Councillor Montague.
Yeah, thanks. I guess Councillor Fry needs a seconder, so I'll second it because we run into just a stalemate if that doesn't happen. So, that being said, I think I want to say a couple of things. One is this is an unusual hearing because usually when we have these short-term rental hearings, it involves unscrupulous owners who are trying to skirt the system, cheat the rules. And that's not something we have here. This, I think, is, we're looking at section 28.1, sub 7 and sub 14. And I actually disagree with the fact that a suspension of this license is because it doesn't adhere to those sections. I think we heard from the city council that in fact, the bylaw does not state that it requires a yearly authorization or permission for each unit. And Ms. Sharapova does have a letter from the strata authorizing that shows proof of strata authorization. That's all the bylaw asks for. It says proof of strata authorization. It doesn't say yearly proof. It doesn't say annual proof. It just says proof of strata authorization. And I believe there is proof of strata authorization. There is a letter. The letter is 2 years old, but it does say that the strata allows short-term rental. And in minutes, it's clear that the strata is trying to potentially change those, change that. But at this point, the evidence that we have shows that the strata still authorizes short-term rental in this building. And I think that's what the rules in the bylaw are asking us to interpret here. Is there proof of strata authorization? Yes, there is. I don't have evidence in front of me that says otherwise. So I can't support upholding the decision. While I respect Sarah and her office and the hard work they do, I think this does fall within a bit of a loophole. And maybe Councillor Fry's right. Maybe it does need a change to the bylaw to ask specifically for an annual authorization from strata, but it doesn't have that now. And we are required, as our city's lawyer says, we are required to follow what's written in the bylaw. For me, the evidence would support issuing the issuance of a license. So I'm going to oppose Councillor Fry's motion. I think we should be issuing a license in this situation here. And I'm hoping that what I just said changes both the minds of my other two panelists here, because I strongly believe that Ms. Sharapova is in compliance with how the bylaw is currently written. Thank you.
Okay, thanks, Councillor Montague. Councillor Fry.
Well, I've submitted the motion and I'll read that out, which, thanks to Councillor Montague for seconding it. I do want to just articulate though that technically this is a new strata since it was re-registered twice since the original strata permission. So again, we are getting into technical loopholes and precedent that I worry, and I again, I'm totally sympathetic to Ms. Sharapova in this particular case, but also it is a new strata registration. Clearly from the documentation, it was re-registered in 2023 and then registered again in 2024 with amendments. Technically, it's not the same strata plan that was registered by the developer in 2021, which had authorized this earlier letter. So I have submitted the motion, which was seconded. Oh, it's on the screen. Great. The business license hearing panel uphold the decision of the chief license inspector to suspend the business license to the licensee for a short-term rental accommodation located at 903-180 East 2nd Avenue on the basis that the licensee is unable to provide strata council authorization per requirements under 28.1 bracket 7 of the business license bylaw number 4450.
Thank you, Councillor Fry, and that was seconded by Councillor Montague. I believe we'll need to go to a recorded vote on this one. So if clerks could just take us there, please. Okay, so that motion carries with myself in favor, Councillor Fry in favor, and Councillor Montague in opposition. Okay, would someone like to move a motion to adjourn? Yep, so moved by Councillor Montague, seconded by Councillor Fry. All in favor, say aye. Aye. So that carries and this hearing is adjourned. Thank you.